So what happens if we've already set up our own estate plan? We've already set up our own trust. We may have funded that trust with bank accounts or savings accounts or investment accounts or our property, our real estate. We've put the real estate into that trust, but then we receive an inheritance. Maybe our parents pass away and they have a trust set up or they have an estate plan set up. What happens then? This is Michael Pevney, and I'm an estate planning lawyer in California. I create estate plans for California families. If you are interested in estate planning, please follow this account and you can go ahead and ask an estate planning question in the comments. I'm often able to get back to them. So let's say that we have our own trust set up. We've set up our revocable living trust with our qualified estate planning lawyer. And then we want to know, and this is a question I get from clients sometimes, we want to know what is going to happen to my parents' stuff. My parents have their own trust set up, and if they pass away, both of them pass away, I know that some stuff is going to be left to me. What happens with that stuff? How does that stuff get into our own trust? So when it comes to a trust, we always have to look at the language of that trust. So I'll give you a couple different scenarios here. So let's say that our parents have set up a trust, and in that trust, it says that the family home, we want to give the right to the kids, maybe more than one child, maybe us and our siblings, to live in that home up until the age that they pass away. And then when the children pass away, we want the house sold and distributed to the grandkids. So we do have a little bit of a property interest into that home, meaning we have the ability to live there up until we're gone, up until our lives are over. And the way that our parents set up that trust is to basically give the right to live in that home to our own kids, to their own kids. And then once they're gone, everything's going to basically kind of skip that generation and end up going to the grandkids. So if there's a trust, we always need to look at the language of that trust. Or in some circumstances, the language might simply say, I want everything divided among my kids. So at that point, when the parents pass away, shortly thereafter, the trust is going to end. Their parents' trust is going to end, and then that property is going to be distributed among the parents' children. So if there's 3 kids, we just divide everything by 3. Oftentimes, if there is a home, the simplest thing to do, frankly, is to usually sell the house, or there might be specific instructions about renting the house out. At that point, the home would likely stay in the trust, and then we would have income distributions to all of the kids. But if it's as simple as, okay, we're just going to sell everything, you end up with a couple $100,000, what do we want to do with that couple of $100,000? And this is where sometimes community property rules come into effect, because if we are married and we receive an inheritance, California is a community property state. And gifts that we receive and inheritances that we received are actually separate property. So if we want that property to remain separate property, maybe we want to keep it in a separate account so that if we end up getting divorced, there's marital issues, something like that, that property is not going to be subject to community property rules. That can be a little bit tricky. You're going to have to keep real good track of it and make sure that nothing from that account is ever used to pay for family expenses like a mortgage on a family home or that sort of thing. We can also put that money inside of a trust. If we've already got a trust set up, even if it's a trust that we own and maintain together with the family, we can put that money into a trust account. Oftentimes, the beginning of the trust will say money that enters the trust as separate property will maintain that character of separate property, like an inheritance or a gift. And it will also say that money or property that enters that trust as community or marital property retains its character as community or marital property. So when it comes to a family home, both people are on the title. The home was purchased during the marriage with income generated by both spouses or by even one spouse, as long as it was generated during the marriage, then that home, the family home, is going to enter as community property. But the inheritance might be separate property. Again, we want to keep close track of that because this is the kind of thing that divorce lawyers have a field day with, and we don't want to necessarily commingle the separate property with the community property. Talk to a qualified family attorney or make sure that money is kept completely separate in a completely separate account. So that's kind of what happens when we receive an inheritance and we already have an estate plan set up. We might have our own estate plan set up. We have to look to the language of our parents' estate plan and what does that estate plan say? Maybe that money actually has to be kept in a trust. Maybe our parents perceived that there might be an issue and they wanted to keep the money away from their children's spouses or maybe their children's future ex-spouses, and that money actually has to stay in that trust and it can only be used for the children's benefit. But that money has to remain in that trust. It is controlled by the trustee, and that trust might exist for a long time. Maybe it can pay for our own benefit. It can pay for grandkids, college, and things like that. But it's never actually going to be in the child's name, so it can ever be at risk for being split up in some kind of a divorce settlement. So the bottom line is, I'm sorry, this is the lawyer answer, right? It depends. So we have to look at the language of the parents' trust. And keeping in mind that inheritances are separate property, but we've got to make sure if we want it to remain separate property, that it remains separate property. So that's kind of what happens if we receive an inheritance from our own deceased parents, and they may have set up a trust, and we want to either make that money part of our own trust. Maybe we want to change it to community property. Maybe we want to let our spouse have rights to that in the future. Or maybe that money in that trust is going to stay in that trust and keep it protected from our own future ex-spouses. So that's kind of what happens if we receive an inheritance when we've already set up our own trust. If you've got questions about this or anything else related to estate planning, you can go ahead and drop a comment in the comment section. I'm oftentimes able to respond to them. Once again, my name is Michael Pevney, Pevney Estate Planning. If you're in California and you've got questions about estate planning, you can set up a time to meet with me for free by going to my website. That should be in the description here, ocestateplanlawyer.com. Thanks for your time. Thanks for your attention.